part of the case that has been filed challenging the issuance of a lease to Sarrai Group by KCB and its official receiver. So the case was essentially supposed to start yesterday, but there was an application filed by Mumia outgrowers inviting the court to allow the matter to be heard by a 3-bench judge. Today, the ruling was delivered, and the judge, Alfred Mabea, was very clear that the application on its face did not meet the constitutional threshold for a matter to be heard by a 3-bench judge, for which matter now the application, such application being dismissed, we proceeded with the hearing of the case, challenging the manner in which the lease was issued for the Mumias Sugar Company Limited was issued to Sarrai Group, which is one of the defendants in the case. So today the plaintiffs have concluded their case, and the defendants have been slated their day to court tomorrow, where they appear and present a case. This is the application being heard is an application for injunction. It is for the purpose of restraining any further operations of the appointed receiver and the purported the person who was leased the properties or the assets of the Mumias Sugar Company Limited. So tomorrow we are going to proceed back in court for the defendants who are opposing the move by some of the plaintiffs and some of the bidders who were not successful. So tomorrow we expect the official receiver and the Sarrai Group will defend their position and explain to the court in details how the successful bidder, being the Sarrai Group, was arrived at. So for today, the plaintiffs have, or the applicants have concluded their case. So it is for the defendants and respondents to present their case. For the application, we are yet to move to the main suit, where the parties will be invited to the court to give testimony, to be cross-examined on the positions they have taken. Equally, the court was kind to decline an invitation to allow an application an affidavit that was filed out of time by the Attorney General. The court directed that since there was no follow-up on the directions of the court in terms of filing of documents, that affidavit will not be considered because it will prejudice some of the parties in the case, and for which they will not have had reasons or chance to respond to the averments in the affidavit. So for today, we have closed the plaintiff applicant's case. So tomorrow we shall appear in court for the defendants. Some of them include Gakwamba Farmers Association, who are our clients, to argue our case for why the court should not interfere with operations of Sarrai Group, which had been issued the go-ahead of processing the assets of Mumias Sugar Company. Thank you.
We have indicated to the public and to the nation at large that several dark forces have been filing cases in different courts, all the way from Kakamega to Vihiga to Nairobi in different divisions, to several judges, and several attempts have been done to make sure that the sweet Mumias Sugar does not become sweet. The matter was slated for hearing yesterday. Still an application was done to empanel the matter before 3 judges, an application that was hopeless. It was not based on any known law, but it was aimed as an application for recusal of the judge. We did tell the judge that that application was purely to attack the person and personality of the judge, and the judge has agreed with us that that application was not an application for empanelment. It was an application that was aimed at demeaning and bringing into disrespect or disrepute the person and capacity of the judge hearing this matter. The same application has been dismissed with costs. We then were order to proceed with this matter. But still, the people who lost the bid, the people who are after making the farmers of Mumias not to get their money, the people are after blackmailing the economy of the country, filed another affidavit today. Yet the judge had given timelines that by the close of business on the 14th, everybody is supposed to have filed their documents. We did again raise that question, and the judge has dismissed that affidavit and struck it out from the court record, and the matter shall proceed. In the substantive application, the plaintiffs presented their argument that they bidded for 36 billion shillings and Sarrai bidded for 5.8 billion shillings. The questions before the court to decide is the capacity to deliver, is not mere utterances that we shall offer 36 billion shillings. Tomorrow at 11:30, the defense team, the respondents, we will proceed to prove that West Kenya has no capacity, has no skill, has no expertise to run a factory like Mumias Sugar. And we shall be moving with speed to make sure that we conclude this matter tomorrow for the court to make a determination. So today marks a celebratory mood for the farmers and the employees of Mumias, because their matter is going to be heard without due regard to technicalities, with the speed, and we believe that justice will be done to the farmers of Mumias and to the citizens of Kenya, and Sarrai Group of companies will deliver the tea, the sugar for tea for Easter holidays. We are definite that Mumias Sugar will be roaring and Kenyans will have their porridge with the Mumias Sugar.